ಲೈವ್ ಕೊನೆಗೆ ಸೆಷನ್ ಎಂಡ್ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಬೇಕಾ ಸರ್? ಹೌದಾ, ಓಕೆ. ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇರುತ್ತೆ ಅಲ್ಲ ಮ್ಯಾಮ್, ಇಲ್ಲಿ ಸ್ಟಾಪ್ ಆಟೋ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಬಟ್ ಇವಾಗ ಆಲ್ರೆಡಿ ಕೊಡ್ತೀವಿ
ಅಲ್ಲ, ಈಗ ನಮ್ಮ ಸೆಷನ್ ಎಂಡಾದಾಗ ಮಾಡ್ಬೇಕಂತ. Any memos?
Lord, sentence is suspended for co-accused, my lords. Kindly have it tomorrow, my lords.
Tomorrow, sir. You file it. Any other?
Kindly wait, madam. List 1, page 5, serial number 14 to 17.
Serial number 15, my lord. 15. Counsel is an abroad, my lord. Can you have it on?
Sir, oldest
seven-
matter.
Please, my
Oldest-
lord, I understand. 17th on 8. Respondent counsel also present, my lord.
I appeal for the respondent.
Both of you should address the argument on the next date. Otherwise, I'll proceed.
Please, my lord.
Whether
Have it
you
on
address the
17th.
argument or not, I am not concerned.
17th on 8.
You understood?
Please, man.
Even if you do not address the argument, I will proceed to dispose of.
Please.
Counsel for the appellant, raise for time. The appeal is of the year 2011. 14 years have elapsed after admitting the appeal for final hearing. The counsel for the appellant and respondent undertake to address the argument on the next date of hearing without fail. Submissions are placed on record. List finally as a last chance. Yes.
Page 6, serial number 18 to 22.
Yeah, number 22, my lord.
22.
For the appellant, man. Kindly out next week, my lord.
Same applies to you also. ಅದನ್ನು ತಗೊಳ್ಳಿ. 2012, 13 years have elapsed after admitting the ಅದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. Yes.
Your Lordship, serial number 20, Your Lordship. It may kindly be had next week, any date, Your Lordship.
Same 2012. ಮೊದಲನೇ ಹಾಕಿ.
Serial number
2012. Serial number 20. ಎಲ್ಲ ಒಂದೇ ಡೇಟ್ ಕೊಡಬೇಡಿ. Yes.
My lord, serial number 19, my lord. I'll go
19.
on Monday, final hearing.
Same 2012 matter.
Monday,
You are
my
for the
lord.
appellant.
I am for the appellant.
12 no same. Undertakes to. Yes.
List 1, page 1, serial number 1, non-compliance for 4th time. Abhimanyu Arjun Devaya.
Lord, all the objections have been complied, my lord, except for two, my lord. One is that the accused copy has been produced instead of certified copy. That may be dispensed with, my lord, because the copy is accused copy. In court kottiyare adne hakidivi. Amele second objection is that, my lord, the de facto complaint is not made a party in this suit because there is special act ide ante ಹೇಳ್ಬಿಟ್ಟು. I'll during the course of the day I'll make him.
Fourth time it is listed.
No, my lord, it was listed before the vacation bench. That's why it's because of fourth.
Why you moved for a vacation bench?
Vacation bench ಅಲ್ಲಿ 2 ಸಲ ತಲುಪಿಲ್ಲ.
Relief ಸಿಗುತ್ತೆ ಅಂತ.
Sorry?
Relief ಸಿಗುತ್ತೆ.
No. ನಾನು ಫೈಲ್ ಮಾಡಿದೆ ವೆಕೇಶನ್ ಟೈಮ್ ಅಲ್ಲಿ ಬಿಕಾಸ್ ಹಿ ವಾಸ್ ಅರೆಸ್ಟೆಡ್. ಅವತ್ತು ಅವನು ಅರೆಸ್ಟ್ ಆಗ್ಬಿಟ್ಟು ಹಿಸ್ ಸನ್ ಇಸ್ ಸ್ವಲ್ಪ ಫಿಸಿಕಲಿ ಚಾಲೆಂಜ್ ಕಂಡಿ.
Now he is released.
No, my lord.
He is in custody.
He is in custody, my lord. For suspension of sentence, it may be posted on Thursday, my lord. During the course of the day,
But you have to comply the other office
I'll
objections.
do, my lord. Only 2 objections are there. One may be condoned, my lord. Second one, I'll do it during the course of the day. That is de facto complaint na party ಮಾಡಬೇಕು ಅಂತ ನಾನು ಮಾಡ್ತೀನಿ.
Office objection at serial. It is stated that the copy of the charge sheet furnished to the accused is produced before this court instead of certified copy. Hence, office objection at serial number 6 is ignored for the present. Next, counsel for the petitioner prays for time to comply with the office objection at serial number 11. The matter is listed for the fourth time for compliance of office objection. List on. Yes, comply with that.
My lord, may I request on Thursday, my lord?
First, you comply with
Yes,
this
yes, I'll do it. Wait.
list after compliance of office objection.
Serial number 2, Mahante Shiramat, connected matter Ismail.
Serial number 2.1, my lord.
Hmm.
We were to furnish the correct address, my lords. Last time we attempted to ascertain and we had sent it to Bombay, my lords. And the investigating officer also was,
In respect of respondent number 2, as per article to directive, etc. Correct address of respondent number 2.
please, my lords. So we had sent it to Bombay initially, my lords. That's the address we had. So we'll just, some more time to ascertain the address. my lord. Even the investigating
Only
officers were,
counsel for the petitioner, appellant prays for time to furnish correct address of respondent number 2. The appeal is of the year 2021. I do not find any reason to adjourn the matter. However, when counsel for the appellant undertakes to get the correct address of respondent number 2 before next date of hearing, information is placed on record. List on. Next to 2 ನಲ್ಲಿ ಏನಾಗಿದೆ police report received. But before next date of hearing, you have to collect the correct address and furnish it.
please.
Then 2 ನಲ್ಲಿ ಏನಾಗಿದೆ police report received. Serial number 2. When counsel for the petition appellant is absent, no representation. Police, as per police report, respondent is not found in the address. However, he is informed through WhatsApp. In spite of that, when counsel for the appellant and the appellant are absent, there is no representation. Then additional government ಯಾರಿದ್ದಾರೆ ನೋಡ್ಕೊಳ್ಳಿ. So and so suggests that the presence of the appellant may not be necessary at this stage and applies for hearing the matter on merits. To hear the appeal on merits, the presence of the appellant is not necessary at this stage. Since the counsel for the appellant is not present before the court, he is directed to address the argument on the next date of hearing. Then a counsel for the appellant is directed to address his arguments on merits on the next date of hearing. It is made clear that if the learned counsel for the appellant remains absent or do not address his argument, then Amicus curiae will be appointed to assist the court for the purpose of disposing the matter on merits. List on. Yes.
Serial number 3, R. Nagendra Nayak, P. Prasanna Kumar, connected matter Shankar Hegde.
My lordship, I appear for the surety. Surety has already paid the amount, my lordship, on 24th and 28th.
What is the
27th.
amount?
And
Could you,
you have paid the memo also on 28th.
no, what is the amount paid by the?
20,000.
Huh?
20,000.
20,000.
Yes, please. Last time the honorable judge has not ordered on the IA, my lordship. So the recalling order may be removed.
When you have deposited?
On 24th, 10,000, my lord, 24th February. On 27th February, another 10,000.
20th April.
No, 24th February.
10,000.
On 27th February, 10,000.
Have you reported the payment?
Yes, we have submitted the receipt, my lordship.
Have you produced?
Yes,
to the
produced
court?
before the court, honorable court.
ಇದು ಶೂರಿಟಿಗೆ NBW ಹಾಕಿದ ಸರಿ ಇರಿ ಅಯ್ಯೋ 1/2025 ಬೈ ಶೂರಿಟಿನ ಹೌದಾ? What was the surety bond amount?
Bond amount was 25,000, my lordship, but 20,000 remittance was there, and the honorable judge has ordered for 20,000, and we have paid that total amount.
ಎಲ್ಲಿದೆ order ಅಲ್ಲಿ 20,000? ಎಲ್ಲಿದೆ? Third learned counsel for the surety on IA1 of 2024, seeking to recall the NBW issued against the surety. It is next part. It is stated that the surety, it is stated that the applicant has stood as surety for the appellant accused and executed a bond for rupees 25,000. As per order dated 24/2/2025. Surety was permitted to pay rupees 20,000 as against rupees 25,000. Next, counsel for the surety submitted a memo reporting payment of rupees 10,000 each on 27/2/2025 and on 24/2/2025. ಅದು first 24 ಹಾಕಿ ಅದು Therefore, learned counsel for the surety prays for allowing IA1 of 2024 NBW issued against the surety. For the reasons stated in submission, IA is allowed. NBW issued against the surety is recalled.
Was issued in criminal appeal number 122 of 12, which is 3.2, my lords.
1 minute. In 3, what happened to the?
My lords, there is an information that the appellant accused is no more. We really require some more time to verify the same, my lords.
Why? Why such time?
My lords,
Can you not verify it?
we were not able to trace him. We shall, some more time, my lords, we will verify it and submit to the.
Then proceed to address the argument on merits. It will be disposed of.
Please, my lords.
Who is for the appellant?
My lords,
Again,
appearing for the appellant in 3 and 3.2, my lords.
Whether your client is alive or not.
My lords, we are also not aware of the same, my lords.
Then
We do
address
not
the
have any
arguments on-
contact with the
Address the
appellants.
arguments on merits.
My lords, some time may be granted, my lords.
Not
2
on
days
that
time
ground,
maybe.
only to address the arguments on merits.
Yes, my lords.
On
We'll
merits,
address
you
it.
have, both of you should address
Please,
the
my lords,
argument.
we shall address.
Learned counsel for the appellant and respondent submit in unison that they could not get any information regarding the death of the appellant and they are ready to address the arguments on merits. Submissions are placed on record. Submission beda. Since the presence of the appellant is not required before this court to hear the matter on merits, both the learned counsel are directed to address their arguments on merits on the next date of hearing without fail. Huh? 1 minute. 3.2 ನಲ್ಲಿ ಅದು ಎಲ್ಲದರಲ್ಲೂ ಮಾಡ್ಕೊಂಡ್ಬಿಡಿ 3 ಎಲ್ಲದು ಕಾಮನ್ ಆರ್ಡರ್ in all the 3 matters.
Please, my lords, in 122 of 12, my lords, police report with respect to the non-execution of NBW, my lords, I shall.
3.2 ನಲ್ಲಿ as per police report, the NBW issued against the appellant could not be executed. ಅದಾದ್ಮೇಲೆ ಉಳಿದಿದ್ದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. Presence of the appellant is not necessary at this stage. Both the learned counsel are directed to address their arguments on merits on the next date of hearing. In all the 3 matters, you should get ready and address the argument.
Next week, any time, my lords.
Yes, date will be fixed.
Please,
On that day, please get ready.
please, my
Next.
lords.
Serial number 4, Mahesh Kiran Shetty.
I appear for the appellant. This 6 matters. He has been convicted for offences under 377 and
How many in all 6 matters?
in all 6 matters. So he has served almost from 17/12/2018. He's in custody and he has served the.
No, all the accused?
My lord, it's a sole accused in all these cases.
Okay. What is the offense?
Offense is 377 of IPC and section 8 of POCSO Act
6 cases.
in 6 cases.
He was in custody during trial. Let him be in. Address the arguments on merits.
Date may be fixed, my lord.
Last. Third learned counsel for the appellant on IA1 of 2022 seeking suspension of sentence and for bail. It is noticed that the appellant is the accused in all 6 similar cases and was convicted in all such cases. It is also noticed that the appellant was in custody even during trial. Therefore, I do not find any reason to either suspend the sentence or to enlarge the accused on bail. Next, the counsel for the appellant undertakes to address the arguments on merits on the next date of hearing. Call for
But records have to be secured. my lord.
records are already received.
Please,
Please get ready and address the argument. No further adjournment will be given.
please.
Yes. For admission, please start.
Serial number 5, Vikram Raj, Kumar Balakrishna.
For the appellant, respondent 2, my lord. Lordships, there are 2 applications, one for continuation of delay. The delay of 9 days, your lordships.
Heard on counsel for the appellant and respondents on IA2 of 2023 seeking condonation of delay of 8 days in preferring the appeal. For the reasons stated in so and so, IA is allowed. Delay of 8 days in preferring the appeal is condoned. What about IA1 of 2023?
Ready, your lordships.
Yes.
I may be applicant file the objection to IA number 1.
Valid. What is your objection? What is your objection?
Objection is that minor girl aged up to 6 years old was
No,
sexually
there is severity of offense is there, of course.
Yes, my lord.
Whether the accused was on bail or not
Was on
during
bail.
trial.
He was on bail.
He was on
2 days he was in custody. Thereafter he was on bail.
Then he is entitled.
And evidence of VW1.
No, that is all on merits of the case. I will consider that.
There is sufficient evidence of fault.
I am not denying that, sir. It is all on merits. Now only with liberty, regarding the liberty of the accused. When he was on bail during trial and there is no allegation that he has misused his liberty, he is entitled for that.
But here in the case, my lord, there is ample evidence, well reasoned order.
Yes. Yes, I am not deciding the appeal at this.
That is correct, my lord.
Yes.
Because the
Heard,
minor
learned.
girl,
Yes.
her evidence was corroborated by.
Sir, I am having all sympathy towards the victim, but it is to be decided. Let me decide it. In I think heard learned counsel for the appellant and respondents on IA1 of 2023. ಅದಕ್ಕಿಂತ ಮೊದಲು learned counsel for respondent number 2 filed statement of objection to IA1 of heard so and so. There is the materials on record. It is noticed that the appellant accused was on bail during trial, even though serious allegations are made against him. The trial court has assigned reasons for convicting him. However, it is not the contention of respondents that the appellant had misused the liberty granted in his favor during trial under such circumstances. ಅದನ್ನ ತಂದು ಫಾರ್ಮೆಟ್ ನಲ್ಲಿ ಇದೆಯಲ್ಲ ಅದನ್ನ ಹಾಕಿ. Hence, IA1 of 2023 is allowed, suspended. IA1 of 1 and 2 are allowed.
Grateful.
All for trial court records. At least for admission.
Grateful.
Serial number 6, R. Rakshit.
Lords, in this case, I appear for the appellant, my lords. Lords, there is 166 days delay in this filing of this appeal, my lords. The accused is in judicial custody.
ಯಾರು ಅಂತ ಅವ್ರು ಯಾರು HCGP ನ ಅಡಿಷನಲ್
Please, madam. HCGP.
HCGP takes notice for respondent.
Lords, I pray time to hear on the suspension of sentence, my lords. Kindly have it on 11th, my lords.
Counsel for the appellant prays for time to address arguments on IA1 and 2 of 2024 this term.
Great list.
Number 7, Raju CN.
Appear for the appellant, my lord. To notice
ಆಗಿಲ್ಲಲ್ಲ HCGP takes notice for respondent. Yes, what about delay?
it's 190 days.
Why there was delay?
Kindly pass out the matter.
You have not read the file.
No, my senior is in.
Why you are standing before the court then?
Sorry, my lord.
You have no idea about the facts.
It's-
Without reading the file, you should never appear before the court. You don't have the file.
Yes, my.
Where is the file? What is the difficulty in opening that?
No, my lord, my senior is another court.
Senior may be anywhere. What is the difficulty for you to read the file? Can you not read it?
Yes, ma'am.
Open it and read.
Kindly pass over the matter.
Read, open the file. Why you are carrying it?
No, my lord, I have in another court, my lord. It's
Maybe, but the file is in your hand. You are in the court.
No, my lord, my file is.
How long it will take to read a application and the affidavit?
No, my lord, it's up. My file is not there, my lord.
What is your name?
Bhavya, ma'am.
This should not be your temperament. Even when I am asking you to open the file, you are not ready to open the file.
No, my lord, I have not.
What is your name?
Bhavya, ma'am.
Huh?
Bhavya.
Tagode avaru. So and so for the appellant is present before the court and prays for time. She is not ready to open the file, even when the court directed her to open the file and make a submission on IA-1 of 2025. The conduct of the counsel representing the appellant is not appreciable. List after 4 weeks. Next. Huh? What is it? Beda. Yenu beda. Next.
Serial number 8, Basuraju TA. TA Basuraju.
My lordship, this is the NDPS matter, my lord. 10 years imprisonment is awarded. There is a 201 days, my lordship, is delay. My lordship, he is Ugandan national. My lordship, before the trial court, free legal aid.
Let him take a notice. HCGP takes
No, my lordship,
notice for
special
responding.
PP, Unni Krishnan M.
Yenu.
Special PP, DRI, my
Special.
central government.
Okay, so and so
M. Unni
special-
Krishnan.
Special PP.
Yes, ma'am.
Special PP is directed to take notice for respondent. Let him appear.
Please.
Yes.
9.
Next.
Hearing to the appellant, your lordships. Appeal filed under section 449. Proceedings initiated against surety, your lordships. The trial court has attained finality, your lordships. So this appeal is infructuous as on.
Appeal is infructuous. Why?
The trial court had proceeded and the proceeding has been closed, your lordships, disposed of.
How?
There was a settlement arrived at and
What is the offense?
it's not an offense, your lordships. Surety proceedings initiated
Surety
against the surety.
proceedings.
Yes, your lordships.
Okay.
A sum of rupees 10,000 was paid off and settled off.
Okay. Counsel for the appellant submits that. The matter is settled between the parties and the appeal has become infructuous. That is before the trial court. And the appeal has become infructuous. Submission is placed on record. IA-1 and 2 of 2025 and the appeal are dismissed as the same are rendered infructuous. Yes.
Serial number 10, Rakshit.
Lords, in this case, I appear for appellant, Lords. There's 11 days delay, my Lords, and the appellant is convicted for the offence punishable under section 363, 341 of IPC, section 8 and 10 of POCSO Act, my Lords. Notice has to be issued to the respondent number 2, my Lords.
HCP takes, and then an additional SPP takes notice for respondent number so and so. Issue notice to respondent so and so. Yes.
11, same.
Pay PF for issuance of notice.
My Lords,
Pay PF for issuance.
please, my Lords. I'll take necessary.
11 same.
11 same, my Lords. POCSO offence.
Yes. Next.
Delay may be condoned, my Lords. Or not.
Barley notice. Yes.
12, Mohan Kumar Ji.
Appearing for the appellant. Lords, the appellant has been convicted for the offence 120B read with 420 of IPC and 13(1)D of PC Act. Lords. There has been a delay of 14 days.
No, what are the offence? 420.
420 of IPC and 120B of IPC and 13(1)D of the PC Act. Lords.
Okay. Special PP na idake? ಇಲ್ಲ ಇವರೇ ನೀವೇ ತಗೋತೀವಿ Additional SPP.
CBI is also there.
Huh?
CBI. State by Inspector of Police is by CBI.
CBI.
CBI, my lords.
Okay, CBI क्या इधर है?
Prasanna Kumar.
हाँ? Prasanna.
Prasanna Kumar.
Special PP. Shri so and so special PP is directed to take notice for respondent. Barlev.
Please, a suspension of sentence of 14 days, my lords.
Huh?
Delay, there is a 14
I'll
days.
consider that. Let
Please,
him
please,
appeal.
please, my lords.
Yes.
Grateful.
Serial number 13, R. Rakshit.
I appear for the appellant, my lords. My lords, in this case, the appellant is convicted for the offence punishable under section 8 and 12 of POCSO Act. There's a delay of 43 days.
He is in custody.
Yes, my lords. He's in custody since 2022, my lords. 2 years, my lords.
Additional SPP takes notice
Emergent.
for respondent. Respondent victim idara.
Yes, my lords. We have made the part.
Notice
Complaint.
to respondent. Issue notice. Pay PF.
Fine. One subject.
Serial number 14, Joseph Venkatesh Sarbati.
Counsel for the appellant is absent, no representation. This is the oldest matter. What do you mean? Huh?
2010 matter.
ಏನು offense?
Section 31E.
Order sheet. Learned counsel for the appellant is absent, no representation. The order sheet dated 27/3/2025, 4/4/2025 discloses that the appellant, the learned counsel for the appellant was not present and there was no representation. The appeal is of the year 2010 and it is the oldest matter pending before this court. It appears the appellant is not interested in prosecuting the appeal. Hence, Yaru, Amicus. Yaru? Shri so and so is appointed as Amicus curiae to represent the appellant and to assist the court.
14.
Learned Office is directed to communicate the order to the Amicus curiae forthwith. The Amicus curiae and the learned counsel for the respondent are directed to address their arguments on the next appeal. Amicus is appointed. On the next date of hearing, you go on with the matter on merits. You prepare a small synopsis or dates and events which are material. Who are the material witnesses? Which are the material documents? And what is the evidence?
In
Is
fact,
there
the
any
appellant was
admission?
dead.
Huh?
In fact, the appellant was dead. And connected matter, his conviction has been upheld by the Honorable Court. In another matter, there are two cases, two appeals.
This appellant is no more now?
Is no more.
Then why, what is the fun in keeping this?
That is why the dictation was commenced on 13/8/2008 by the Honorable Court. At that time, the learned counsel for the appellant would submit, Mr. Joseph would submit that the appellant is dead. This court
On which date?
ಇದಲ್ಲ. 22/6/2020 and before that
ಅದೆಲ್ಲ ಬೇಡ. ಅದು ಬೇಡ. Counsel for the appellant is absent, no representation. ಅದೆಲ್ಲ ಇರಲಿ. Order sheet dated so and so, absent, no representation. Next, ಅದು ಮುಂದಿನ ಬೇಡ. Proxy counsel ಯಾರು? ಇಲ್ಲ, ಸಾರಿ, ಅದು ಬೇಡ. Amicus ಬೇಡ. Next, order sheet dated 22/6/2020 discloses. that the learned counsel for the appellant has reported death of the appellant. Till today, no steps are taken in that regard. Hence, appeal is already abated. Accordingly, it is dismissed. Dismissed as abated.
Great.
Serial number 15 Arjun, 16 J. Kittur.
Send back.
Lord, I have been appointed Amicus curiae.
Now, those 16.
16.
Huh.
Lord, I submit that I've been appointed Amicus curiae.
Hmm.
I came to know yesterday only when it is listed. I'm ready.
Communicate,
I can, if papers are supplied, my lord, in fact, I was not brought to my knowledge.
Sir, you are appointed in the year 2016.
Yes, my lord, that also I never knew. If there was intimation, I would have.
Communicated to you.
I'm regularly coming, but yesterday only I came to know when it is listed.
Are you interested in representing?
No, I want papers, I will argue. In a short date, I will argue. I know it is the oldest case.
Amicus curiae
I may be furnished with paper book and case papers.
It as amicus only yesterday. Even though he was appointed today, order dated 18/7/2016. The office was directed to furnish paper book to amicus curiae. Office to verify as to whether the order dated 18/7/2016 was communicated to him and whether the papers of the case was furnished to him. You take the copy and get ready on the next date of hearing.
Yes, my lord.
Learned amicus curiae undertakes to
The date may be given. Could it be in second week or third week? I shall get
ready
it.
to address the arguments on the next date of hearing without fail. Submission is placed on record list. Yes, next.
Serial number 17 Mohammed Mubarak, connected matter, Bhagwan, RLN Murthy.
Yes.
Lord, I'm for the appellant in 17.1, that is Appeal 430 of 2012.
Where is this 17 Mubarak, Mohammed Mubarak? How many cases are there?
The 3 cases, my lord.
Three.
Totally
They are
8
the-
accused.
Huh?
Totally 8 accused, 3 appeals, separate appeals.
Yeah, please. Where are the other two? RLN Murthy. Address the arguments on merits and proceed. Put it. Who is for the, you are for the respondent?
I pray for some time, my lord, because the file is not there in all the.
File ಬಿಟ್ಬಿಡಿ ಅದು ಬರೋದಿಲ್ಲ ಅದು ಫೈಲ್ ಎಲ್ಲ ಇನ್ನೆಲ್ಲ ಕೊಡ್ಲಿಕ್ಕೆ 13 years.
It appears senior counsel Mr. Pasha is not there today. He is in the first appeal.
I'm applying for the accused number 6, my lord.
Appeal
Appeal number
485.
485 of 2012. At least 2 days accommodation.
Sir, these matters are of the year 2012.
Correct.
Oh.
If one opportunity is given, my lord, will.
No further adjournment.
Yes.
And you please inform this to your counterpart in serial number 17.2 also.
Please.
Let him come. Even if he does not come, I will proceed. Please communicate this. Learned counsel for the appellant and respond and learned.
I am ready, my lord. That may be not. I am ready, my lord.
ಅದರಲ್ಲಿ 17 and 17 ನಲ್ಲಿ ತಗೊಳ್ಳಿ. Learned counsel for the appellant and learned HCGP pray for time to address their arguments on merits. The appeal is of the year 2012. I do not find any reason to adjourn the matter. Both the learned counsel undertake to address their arguments on the next date of hearing without fail. Submissions are placed on record. List finally as a last chance. 17. 17.1 ನಲ್ಲಿ counsel for the appellant is ready to address the argument. However, learned HCGP prays for time. Number 17.2 ನಲ್ಲಿ learned counsel for the appellant is absent. Learned HCGP prays for time. Learned HCGP undertakes to address the argument on all the matters on the next date of hearing without fail. List Finally, as a last chance. Yes.
Any date may be fixed.
It will be fixed, sir. Later you can collect it.
Kindly not on 9th, my lord, any day after 9th.
9th Agala.
Please,
Any day afterwards.
please.
Yes.
Great.
Serial number
But
18.
prepare a small synopsis or.
It's ready.
Is ready. Yes.
It's 399 in 400, my lord. It's a very short matter.
But you have to mention who are the material witnesses.
Yes,
Is there any admission in their evidence?
please.
And what are the material documents to?
Only police witnesses, my lord. Independent witnesses, Mazar witnesses have not supported prosecution.
You refer to the hostile witness also.
Please.
Who have turned hostile.
Please.
Serial number 18.
I think in one case, if it is prepared, it is sufficient.
That is sufficient, my lord. We are all same.
Same facts. Yes.
18. Shivakumar Gogi.
Appearing for appellant, your lordship. Lordship, I pray for 2 weeks of time, your lordship.
Why?
A senior has is incompetent to appear in this matter, your lordship. He has become AAG. Some other senior has to be appointed in this, your lordship. So,
For appointment, I will not adjourn. I will simply dismiss the appeal.
your lordship. Senior has
No, no,
become.
no.
There's
13
also
years have already lapsed.
one
When he
chance.
was appointed as AGA,
AAG, your lordship.
when
1.5 year, 2 years back.
still you are sleeping over the matter.
You have to seek
Because we are adjourning
instructions.
the matter. You are not feeling the pinch. 1.5 years.
Yes, your lordship.
And you are saying the courts are responsible for delay. Are you not responsible?
Yes, your lordship. Indeed.
Now there are nobody on record.
No, your lordship.
File a memo undertaking to appear. Otherwise,
sir.
I'll straight away dismiss.
No, I'll file a memo.
File
for
a memo.
I'll file a memo
Give your
for
name.
retirement. Yes.
Tagoli. So and so submits that she will represent the appellant and file the memo of appearance as Sri so and so Shivakumar Gogi, representing the advocate on record, is already appointed as AAG and is not representing the appellant and not representing the is
One submission. Your lordship.
and not Counsel on record fails to address the argument, the court will proceed to consider the appeal on merits and dispose of the same in accordance with law. Yes, next.
Serial number 19 and 20 adjourn. 21 KBK Swami.
The
KBK
appellant is
Swami.
absent, no representation. The appeal is of the year 2012. "13 years have lapsed. I do not find any reason to adjourn the matter. Learned counsel for the appellant is directed to address arguments on merits on the next date of hearing without fail. Failing which, the court shall proceed to dispose of the appeal on merits in accordance with law. Next.
22 adjourn. 23 Duranisa.
ಕೊಡಿ. ಈ 3 year ಹಾಕಿದ್ದು.
23.
Appearing for the appellant, I pray for weeks time, my lord. Weeks time.
You're for the appellant.
Yes, ma'am.
You filed the application last year seeking early hearing.
If I do, my lord.
Huh? Still you are not ready.
Yes, Monday, I go on. Yes, Monday.
Counsel for the appellant prays for time. The appeal is of the year 2020. IAs 1 to 3. IA number 2 of 2020 is pending since 2020. I do not find any reason to keep IA 2 of 20 and 1 of 2024 anymore. Means both the applications are dismissed. Next, IA 3 of 2025 was filed by the counsel for the appellant for early hearing. Even when the matter was listed for hearing, counsel for the appellant is not ready. However, this purpose is served. Finally, as a last chance, no further adjournment will be given.
For admission, serial number 24, Sirajuddin Ahmad.
Amendment should be carried out.
Amendment not carried out. Madila.
Amendment should be carried out.
You are not entitled for the benefit now. When the order was passed in the month of April,
Vacation.
you do not find the time to amend the appeal memo till date.
No, no, I'll
Pass
vacation or that.
Vacation andre ಹೋಗ್ಬಿಡೋದು ಎಲ್ಲ ಬಿಟ್ಟು. Next. Do the needful.
Serial number 25, ceased.
Next. Do the needful.
Serial number 25, ceased.
2024. Without getting the FIR, you filed the appeal.
My lords, when I filed the appeal, it was in FIR stage only. Now
Maybe,
the
sir. FIR was there, FIR was registered.
Yes,
Why you have not obtained the FIR? There cannot be any justification. Counsel for the appellant prays for time. The appeal is of the year 2024, seeking bail under section 14A(2) of so and so. This is the Prevention of Atrocities Act. It appears the appellant is not interested in prosecuting the appeal. However, to afford final opportunity this time. Finally, it is posted. No further adjournment will be given. Next.
Serial number 26, Harish Badari. 26.
Counsel for the appellant is absent, no representation. List after 6 weeks.
27, Hirematted Maheshaya Rudraya.
Kindly pass over. Kindly pass over.
Why pass over?
Just now I got the file, madam. Morning only. I'll address the arguments afternoon.
You are not on record?
I'm not on record. I'm a representative, I'm associate of MR Hiremat.
Yes, pass over.
Serial number 28, Harsima Raju.
Appellant. This for the anticipatory bail. A charge sheet is filed.
Notice is not yet ordered. Additional SPP takes notice for respondent.
Notice is already ordered.
Ordered. When? Notice agila. Notice is not yet ordered. Not yet ordered.
Please.
Issue notice to respondent number 2.
I sought for anyway, the proceedings also stayed.
Pay PF for issuance of.
Please,
notice.
please.
Yes.
29, R. Girish. Girish R.
Counsel for the appellant is absent, no representation, list after 6 weeks.
30, Raju CL. Raju.
The same. Next.
Serial number 31, Ravi Kumar Anna.
Appellant seeking for the anticipated bail mail. But the appellant arrayed as the accused number 2 mailer.
Notice agida. Agida. Sir, yes.
The appellant is a accused number 2 mailer.
Accused number 2. What are
Accused
the
number
offense?
2. The offense mailered 352 and 118 1 of BNS Act mailer, and section 31S and 32 VA of Scheduled Caste and Scheduled Tribes Prevention Atrocities Act mailer.
How many accused are there?
2 accused mailer. Accused number 1
What
got
about A1?
accused number 1 has got anticipated bail before the Sessions Court mailer.
Have you produced the order?
In the order mailer, it is mentioned mailer.
What is the allegation?
Annexure C mailer.
You are the main accused.
Mailer
Number 2.
accused number 2. Accused number 1 mailer, he belongs to Scheduled Tribes. That is why the Sessions Court has granted the bail. He
what
belongs to upper caste
What
because
is the allegation?
allegations mailer at the complaint at the next
Come to page number 9.
mailer, the 13 mailer, typed copy of the complaint.
Come to page number 9.
9 mailer.
List of complaint is there.
Yes, ma'am. Shall I read the complaint?
Yeah, please read.
ದಿನಾಂಕ 3/3/2025 18:30 ಗಂಟೆಗೆ ಠಾಣಾ HC 69 ವಸಂತಕುಮಾರ್ ಅವರು ಮೂಡಿಗೆರೆ MG ಹಾಸ್ಪಿಟಲ್ ಒಳರೋಗಿಯಾಗಿ ಚಿಕಿತ್ಸೆಯಲ್ಲಿದ್ದ ಪ್ರಮಿತಾ ಬಿನ್ ಮಣಸಯ್ಯ 40 ವರ್ಷ, ಪರಿಶಿಷ್ಟ ಜನಾಂಗ, ಕೂಲಿ ಕೆಲಸ, ವಾಸ ಚೌಡಿಗುಡಿ ಹತ್ತಿರ ಕುಂದೂರು ಗ್ರಾಮ, ಮೂಡಿಗೆರೆ ತಾಲೂಕು, ಚಿಕ್ಕಮಗಳೂರು ಜಿಲ್ಲೆ ಅವರು ಹೇಳಿಕೆ ದೂರನ್ನು ಪಡೆದು ಠಾಣೆಗೆ ತಂದು ಹಾಜರುಪಡಿಸಿದರ ಸಾರಾಂಶವೆಂದರೆ, ನಾನು ಈ ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ನನ್ನ ತಾಯಿ ದೇವಮ್ಮ ಅವರ ಜೊತೆ ವಾಸವಾಗಿದ್ದೇನೆ. ದಿನಾಂಕ 2/3/2025 ರಾತ್ರಿ 9 ಗಂಟೆ ವೇಳೆಯಲ್ಲಿ ಕುಡಿಯುವ ನೀರಿನ ವಿಚಾರದಲ್ಲಿ ನಮ್ಮ ಮನೆಯ ಹತ್ತಿರ ನೀರು ಹಾಯಿಸಲು ಬಂದಿದ್ದ ನಮ್ಮ ಮನೆಯ ಪಕ್ಕದ ವಾಸಿ ಸುರೇಶ ಬಿನ್ ಕುಮಾರಯ್ಯ, ಪರಿಶಿಷ್ಟ ಜನಾಂಗ, ಅವರನ್ನು ನಮ್ಮ ಮನೆಗೆ ನಲ್ಲಿ ನೀರು ಸರಿಯಾಗಿ ಬರುತ್ತಿಲ್ಲ, ನೀವು ನಲ್ಲಿಯನ್ನು ತಿರುಗಿಸ್ತೀರಾ ಎಂದು ಕೇಳಿದ್ದಕ್ಕೆ ಸುರೇಶ್ ಅವರು ಬಾಯಿಗೆ ಬಂದಂತೆ ಬೈದು ಕೆಟ್ಟ ಪದಗಳಿಂದ ನನ್ನ ತಾಯಿಗೆ ಅಂತ ಹೇಳಿ ಬೈದು ಗಲಾಟೆ ಮಾಡುತ್ತಿದ್ದಾಗ, ನಲ್ಲಿ ಇರುವ ಜಾಗ ನಿಮ್ಮ ಅಪ್ಪನದಲ್ಲವೆಂದು ಜೋರಾಗಿ ಜಗಳವಾಡುತ್ತಿದ್ದಾಗ ಅಲ್ಲಿಗೆ ನಮ್ಮ ಊರಿನ ಅನಿಲ್ ಬಿನ್ ಕೆಂಚೇಗೌಡ, ಒಕ್ಕಲಿಗ ಜನಾಂಗ, ಅವರು ಸುರೇಶ್ ಅವರಿಗೆ ಏನು ಹೇಳದೆ ನನಗೆ ಮಾತ್ರ ಬಾಯಿಗೆ ಬಂದಂತೆ ಕೆಟ್ಟ ಪದಗಳಿಂದ ಬೈದು ನಿಮ್ಮ ಜಾತಿಯ ಹಣೆ ಬರವೇ ಅಷ್ಟು ಎಂದು ಹೇಳಿದವನೇ ಅಲ್ಲೇ ಬಿದ್ದಿದ್ದ ಒಂದು ರೀಪರ್ ಅನ್ನು ಎತ್ತಿಕೊಂಡು ನನ್ನ ಎಡಗಣ್ಣಿಗೆ ಉಬ್ಬಿನ ಮೇಲಕ್ಕೆ, ಹಣೆಯ ಹತ್ತಿರಕ್ಕೆ ಹಾಗೂ ತುಟಿಯ ಹತ್ತಿರಕ್ಕೆ ಹೊಡೆದು ಹಣೆಯ ಹತ್ತಿರ, ತುಟಿಯ ಹತ್ತಿರ ಹಾಗೂ ಒಂದು ಹಲ್ಲಿಗೆ ಪೆಟ್ಟಾಗಿದ್ದು, ನಾನು ಕಿರಿಚಿಕೊಂಡಾಗ ಅಲ್ಲೇ ಇದ್ದ ಯೋಗೇಶ ಮತ್ತು ನನ್ನ ತಾಯಿ ಬಂದು, ಯಾಕೆ ಹೀಗೆ ಪ್ರಮಿತಗೆ ಹೊಡೆಯುತ್ತಿರುವೆ ಎಂದಾಗ, ಅಷ್ಟರಲ್ಲಿ ಅನಿಲ್ ಮತ್ತೆ ಸುರೇಶ್ ಅವರು ಅಲ್ಲಿಂದ ಹೊರಟು ಹೋಗಿದ್ದು, ಸುಸ್ತಾಗಿದ್ದ ನನ್ನನ್ನು ಯೋಗೇಶ ಮತ್ತು ನನ್ನ ತಾಯಿ ಉಪಚರಿಸಿ ರಾತ್ರಿ ಆ ವೇಳೆಯಾಗಿದ್ದರಿಂದ ಯಾವುದೇ ವಾಹನ ಬರದೆ ಇದ್ದುದರಿಂದ ದಿನಾಂಕ 3/3 own certificate mailed is not, own certificate has not furnished mailed.
Yes. Do you
And
have your own certificate?
I'll furnish.
Take Allah.
And the last mailed, the complainant was present before the Sessions Court also mailed. Physically she is present, and immediately next day she was discharged, and she has taken initial treatment, and injuries also not serious mailed. Only the
ಬೇಕಲ್ಲ ಸರ್, ಏನಾದ್ರೂ ಬೇಕಲ್ಲ, ನೀವು ಹೇಳಿದ್ದನ್ನೇ ಎಲ್ಲ ನಂಬುದಾದ್ರೆ ನಮ್ಗೆ.
ಹೌದು, ಅವ್ರಿಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿತ್ತು ಟು ಸೆಕ್ಯೂರ್ ದಿ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್. ನಾವು ಕೇಳಿದ್ರು ಕೊಡ್ಲಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ.
To secure the records.
I'll secure my lord.
Reduce it immediately. The anticipatory bail ಇದ್ದಾಗ immediately you should get it.
Please, I'll secure it. Allegation only one, my lord. ನಿಮ್ ಜಾತಿವರೇ ಇದು ಹಣೆ ಬರ ಅಂತ ಹೇಳಿದಕ್ಕೋಸ್ಕರ ಅಟ್ರಾಸಿಟಿ ಕೇಸ್ ಹಾಕಿರೋದು ಅಷ್ಟೇ.
29(5) there is a direction.
I'll secure it, my lord. Short date, my lord.
Third limit counsel for the appellant. Learned HCGP raised for time to get
ಹೌದು.
the copy of the wound certificate.
ಅದೇ ಉಂಟು ಇಂಜುರಿ.
Order sheet dated 29/5/2025 discloses that the learned HCGP had sought for time to get the wound certificate, but till today, the document is not produced with the court. Learned HCGP undertakes to do the needful within 2 days. This time.
Allegation made in the complaint does not attract the Atrocities Act because he has not raised any words, my lord, that is why.
Just a wound certificate
wound
produced
certificate. Oh.
Monday.
My lord, much obliged.
Serial number 32, P. Latif.
Blood seeking for the anticipatory bail, my lord. This appellant is accused, read as accused number 2, my lord. Notice has not been issued. So.
Issue notice. HCGP takes notice for respondent number 1. Issue notice to respondent number 2. Pay PF for issuance of.
Please.
33, P.S. Puneet.
Respondent number 2, Lord, appeal under section 14 of SCS Act by lots.
Yes. You are for?
Complaint, defective complaint.
Respondent number 2.
Yes.
But you have not appeared. Have you filed wakalat? Yellide. Unrepresented ಅಂತ. When you filed the wakalat? Yesterday. ಅದು ಅವ್ರ ಹೆಸರು ತಗೊಳ್ಳಿ. So and so submits that he has filed wakalat for respondent number 2. Office to verify and show his name in the cause list.
My lord, appeal under section 14 of SCS Act, my lords. My lords, appellant herein is accused number 3, my lords. In total, there are 5 accused, my lords.
Yes.
In total, 5 accused, my lords. My lords, alleged offence are 149, 376 class 2, class N, 376 class D, 376 class 3 of IPC, and section 10(4)(6) of POCSO Act, my lords, and 3 class 1 read with 3 class 2, class V of SCS Act, my lords.
Even charge sheet is already filed.
Even charge sheet is filed, my lords. My lords, coordinate bench of this honorable court had granted bail for accused number 1, my lords.
No, you are shown as absconding in the charge sheet.
No, my lords. He's in judicial custody from 5 months, my lords.
In his regular bail.
Regular bail.
Anticipated bail.
No, my lords.
When he was arrested?
My lords, 13/12/2024, my lords.
Who are on bail?
My lords, accused number 1 and 4 as accused number 1 for accused number 1, coordinate bench of this honorable court has granted bail, my lords. So, for accused number 4, session court has granted bail, my lords.
What about other accused?
Other accused, for accused number 2, they have filed application, my lord. It is still pending, my lords.
5?
3 for orders it is there today in session court.
You are 3.
No, sorry, my lords. 4 for orders it is there in session court today.
4 is already on bail.
5, my lords. 4 has granted. 5 for 5 with orders.
Bail applications are pending.
Pending, my lords. Only on the ground that the DNA report is not matching with the male abortus which has been medically aborted and the present petitioner appellant here in, my lords. Annexed D, my lords.
You come to page number 41. Please read it.
Please, my lords. ಸಾಕ್ಷಿ 2 ಅವರು ಶಾಲಾ ದಾಖಲಾತಿ ಪ್ರಕಾರ ಹುಟ್ಟಿದ ದಿನಾಂಕ 16/8/2010 ಆಗಿದ್ದು ಆರೋಪಿ 1ರಿಂದ 5ರವರೆಗೆ ಸಾಕ್ಷಿ 2 ಅಪ್ರಾಪ್ತರಾಗಿರುತ್ತಾರೆಂದು ಆರೋಪಿ 2, 3, 4 ಅವರಿಗೆ ಸಾಕ್ಷಿ 2 ಆದಿ ಕರ್ನಾಟಕ ಎಸ್ಸಿ ಜನಾಂಗಕ್ಕೆ ಸೇರಿತರಾಗಿರುತ್ತಾರೆ ಎಂದು ತಿಳಿದಿರುತ್ತಾರೆ. ಆರೋಪಿ 1, 3, 4 ಮತ್ತು 5ರವರು ಆತ್ಮೀಯ ಸ್ನೇಹಿತರಾಗಿದ್ದು ಆರೋಪಿ 1, 3, 4, 5ರವರು ಕೆಲಸವಿಲ್ಲದಿದ್ದಾಗ ಆರೋಪಿ 2ರವರ ಚಿಲ್ಲರೆ ಅಂಗಡಿ ಹತ್ತಿರ ಹೆಚ್ಚಾಗಿ ಕುಳಿತುಕೊಳ್ಳೋರಾಗಿರುತ್ತಾರೆ. ಸಾಕ್ಷಿ 2ರವರು ಸ್ವಲ್ಪ ಬುದ್ಧಿಮಂದರಾಗಿದ್ದು ಆರೋಪಿಗಳು ಇದನ್ನೇ ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡು ಕಳೆದ 7-8 ತಿಂಗಳಿಂದ ಆರೋಪಿ 1 ಸಾಕ್ಷಿ 1ರವರ ವಾಸದ ಮನೆಯಲ್ಲಿ ಸಾಕ್ಷಿ 2ರವರ ಮೇಲೆ ಆಗಾಗ ನಿರಂತರವಾಗಿ ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯವೆಸಗಿದ್ದು ಆರೋಪಿ 3ರವರು 7-8 ತಿಂಗಳ ಹಿಂದೆ ಒಮ್ಮೆ ಲಕ್ಷ್ಮೀದೇವಿ ದೇವಸ್ಥಾನದ ಪಕ್ಕದಲ್ಲಿರುವ ಸಾಕ್ಷಿ 6ರವರ ಹುಲ್ಲಿನ ಮೆದೆಯ ಹತ್ತಿರ ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯವೆಸಗಿದ್ದು ಆರೋಪಿ 5 ಕಳೆದ 8-10 ತಿಂಗಳಿಂದ ಹಲವು ಬಾರಿ ಸಾಕ್ಷಿ 5ರವರ ಕಬ್ಬಿನ ಗದ್ದೆಯಲ್ಲಿ ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯವನ್ನು ಎಸಗಿದ್ದು ಮತ್ತೆ ಈಗ 5-6 ತಿಂಗಳ ಹಿಂದೆ ಆರೋಪಿ 1ರಿಂದ 5ರವರು ಸಾಕ್ಷಿ 5ರವರ ಕಬ್ಬಿನ ಗದ್ದೆಯಲ್ಲಿ ಸಾಮೂಹಿಕವಾಗಿ ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯವನ್ನು ಎಸಗಿದ್ದು ಅದಾದ ನಂತರ ಸಾಕ್ಷಿ 6ರವರ ಹುಲ್ಲಿನ ಮೆದೆಯ ಹತ್ತಿರ ಆರೋಪಿ 1, 3, 4, 5ರವರ ಸಾಮೂಹಿಕವಾಗಿ ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯ ಎಸಗಿದ್ದು ಕಳೆದ 3-4 ತಿಂಗಳಿಂದ ಸಾಕ್ಷಿ 2 ಅವರ ಮಂತ್ಲಿ ಪೀರಿಯಡ್ ಆಗದ ಕಾರಣ ದಿನಾಂಕ 29/10/2024 ಸಾಕ್ಷಿ 1 ಮತ್ತು 3 ಅವರ ಸಾಕ್ಷಿ 2 ರವರನ್ನು KR ಪೇಟೆಯ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯ ವೈದ್ಯರಿಗೆ ಕರೆದುಕೊಂಡು ಬಂದಾಗ ಸಾಕ್ಷಿ 12 ಅವರವರು ಪರೀಕ್ಷೆ ಮಾಡಿ ಸಾಕ್ಷಿ 2 ರವರು 18 ರಿಂದ 20 ವಾರಗಳ ಗರ್ಭಿಣಿ ಆಗಿರುತ್ತಾಳೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ.
What is the age of CW2?
15 years as stated by her mother, my lord.
The date of the offense, my lord, she was 14 years old. Repeated gang rape.
Yes, what do you say?
Lord, as the last occasion, my lord, when bail was granted, the complainant, my lord, is extremely poor. They were not able to engage any lawyer. In fact, though they were served, they were underrepresented before this honorable court. The law, my lord, is very clear. This is a POCSO offense. Charge sheet has been filed.
Co-accused are already enlarged on bail. Similar allegations are made.
My lord, even in
Parity.
Parity, my lord, in fact, there's a judgment I've denied by this honorable court that parity, but rightly cannot be said that parity suit has to be done. It will have to be seen what are the allegations that have been made against this particular accused.
No, when similar allegations are made against two accused and one of the accused is already on bail, why that benefit is to be denied to the other accused?
My lord, in fact, my lord, the only ground is that the DNA is not matching. That's the only ground. The Bombay High Court, my lord, in almost similar kind of circumstance, has held that.
See, that is on merits of the case.
Please.
Now I am asking you regarding parity.
Please, my lord. On parity, my only submission is.
See, allegations against accused number 1 and 5 are very serious.
Please, my lord. And all of them, my lord. In fact, all of them
And
are
similar allegations of gang rape.
Please, my lord.
And all those accused are accused number 1 and 4 are already on bail.
Please.
Then
No, no, I'm only trying to. In fact, my lord, what I have also advised our clients is that they will have to consider now for challenging ways that have been granted. Because this offense, my lord, is an unconscionable offense.
Of course, there is.
Repeated gang rapes of this girl, my lord, from the time she was 13 to 14 years old.
What is the age of this petitioner?
28 years, my lord.
28 years.
8 years.
What girl is of the year 14?
14.
My lord, it's a
How
clear
far we say?
unbiased allegation, my lords. Even the DNA reports are not only this petition, my lords.
Necessary, sir. DNA not necessary.
My lords, not only this appellant, my lords, all the what allegations made against all the accused, my lords, not even 1% DNA is not matching with that accused.
DNA not necessary, sir.
My lords,
That's what the Bombay High Court
Suppose
has
the girl does not become pregnant. Do you mean to say the accused is to be acquitted?
no, my lords.
Then
My lords, the male about
gang rape, DNA will not match.
my lords, the male abortus.
Common sense.
Please.
That cannot be the ground for enlarging you on bail. Where is the order passed in favor of accused number 1 and 4?
Madam.
What is-
Madam.
They ground, my lord. DNA doesn't match at ashte. Nothing else has been considered. Dual notice, I mean, respondent.
You have not challenged this order, neither sought for cancellation.
This particular family, my lord, they belong to the lowest of the low category, my lord. Extremely poor. ಕೂಲಿ ಕೆಲಸ ಮಾಡ್ಕೊಂಡು ದುಡ್ಕೊಂಡು ತಿನ್ನೋರು. ಇವ್ರಿಗೆ ಬೆಂಗಳೂರು ಹೈಕೋರ್ಟ್ ಅಂತಾನೆ ಅವ್ರಿಗೆ ಏನ್ ಗೊತ್ತಿಲ್ಲ ಅವ್ರಿಗೆ.
Very sad.
In fact, my lord, Atrocities Act, section 14A, my lord, 15A. The victim, my lord, has so many protection under that statute.
Of course, that is there, but that is to be availed.
Yes, Swami, but if somebody like this, my lord, who is so poor, so downtrodden in society, daily wages, belonging to the Dalit communities.
You file objections, let me see.
I'll file an objection.
File objections. ಅದು ಅವ್ರದ್ದು ಹೆಸರು ಆಯ್ತಾ? He seeks time to file objections to the bail application. Seeks time to file statement of objections. ಅದರ ನಂತರ counsel for the appellant filed a memo reducing the order granting bail in favor of accused number 1 either.
Accused number 1, my lords.
1. This come. ಯಾವಾಗ Monday, Tuesday?
My lord,
Next week I'm traveling, my lord. It can be at end of this week or on
Bail matter, ಇವನ್ನೆಲ್ಲ ಇಟ್ಕೊಂಡು
Friday
ನೀವು traveling ಅಂತ.
ಇಲ್ಲ next week ನಾನು ಊರಲ್ಲಿಲ್ಲ. Either this Friday, my lord, or on 18th, 17th.
Friday.
Grateful.
Serial number 34. Chandrasekhar B.
ಮುಗಿದೋಗಿತ್ತಲ್ಲ. ಈಗ ಫೈನಲಿ ಅಂತ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ, ಎಷ್ಟು ದಿನಕ್ಕೆ ಒಂದು 4 ಫೈನಲ್ ಇರೋದನ್ನ ಹಾಕ್ಬೇಕು. ಮಿನಿಮಮ್ 4, ಮ್ಯಾಕ್ಸಿಮಮ್ 6. ಇಲ್ಲ 10 ಬೇರೆ ಇರಲಿ, ಫೈನಲಿ ಅಂತ ಪೋಸ್ಟ್ ಆಗಿತ್ತು. ಹೌದು, ಪರ್ ಡೇ ಮಿನಿಮಮ್ 5 to 6 ಇರಲಿ. ಹಾಂ, TCR ಜಜ್ಮೆಂಟಿಗೆ, ಜಜ್ಮೆಂಟ್ ಬಿಗಿನಿಂಗಿಗೆ ಎಂಡಿಗೆ, ಆಮೇಲೆ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ, PM ರಿಪೋರ್ಟ್ ಇದೆ, ವಿಟ್ನೆಸ್ PW1 ಇದೆ, ಎಕ್ಸಿಬಿಟ್ಸು ಎಕ್ಸಿಬಿಟ್ P1 ಇದೆ. ಅಷ್ಟಕ್ಕೆ ಹಾಕಿಡಿ. ಎಸ್ 34.
Serial number 34. Chandrasekhar B.
ಇದು ಮೊದಲಿಂದು ಇದು ಅರ್ಜೆಂಟ್ ಆಯ್ತಲ್ಲ, ಅದಕ್ಕೆ 34 ಚಂದ್ರಶೇಖರ್, ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪೆಲೆಂಟ್ ಇಸ್ ಅಬ್ಸೆಂಟ್, ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್. ಆಗಿದೆ, ನೋಟಿಸ್ ಆಗಿದೆ ಇದು. ಇಲ್ಲಲ್ಲ, ಆಗಿಲ್ಲ ಅಂದರೆ HGP ಟೇಕ್ಸ್ ನೋಟಿಸ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ದಿಸ್ ಟೈಮ್. ನೆಕ್ಸ್ಟ್
35. Vijay Kumar T.
Petitioner. Seeking transfer.
ಯಾರಿಗೆ ನೋಟಿಸ್ ಆಗಬೇಕಲ್ಲ?
My lord, the first respondent is the husband of the petitioner, my lord. The petitioner herein has filed a petition, criminal mispetition.
I will issue notice.
My lord, kindly seeking stay, my lord.
Stay ಏನಕ್ಕೆ?
Stay the.
In which court the matter is pending now?
My lord, before the additional chief judicial magistrate, rural court, Bangalore, my lord.
Bangalore, huh?
I'm seeking transfer from Bangalore to Hassan court, my lord.
You are presently residing in Bangalore. What is the difficulty?
Now presently residing and staying at Hassan, my lord.
ಎಲ್ಲಿದೆ ನೋಡಿ ನಿಮ್ಮ cause list ನೋಡಿ.
This is as per the, I have mentioned in the memorandum of petition, as per the trial court.
Cause list, sorry, cause title.
As per the trial court cause title, my lord.
Whatever it is, you say presently I am residing in Bangalore.
Otherwise, my lord, office has raised the objection. That's why, as per the cause title, I have mentioned there.
Sir, you are an advocate, not a layman. You should understand the consequences.
But
in the cause title, you say presently residing in Bangalore.
as per the cause title. That's why, my lord, I am producing the Aadhaar card also. And one more thing, one more submission, my lord. The respondent also has filed a MC petition seeking restitution of conjugal rights. That case pending before the Hassan, my lord.
Barli. You should not pay PF immediately. Next date, consider.
Till next date, seeking stay.
Stay. ನೀವು specifically ಹೇಳಿದ್ರಿ ಬೆಂಗಳೂರು presently residing.
As per the trial court judgment, my lord.
Sir, you cannot disown your own pleadings. You are bound by that.
Trial court judge. Trial court cause title ಪ್ರಕಾರವಾಗಿ ಮೆನ್ಷನ್ ಮಾಡಿ.
Advocate,
ಇದು ಏನಾಗುತ್ತೆ?
abundant ಸ್ವಲ್ಪ ಅಲ್ಲ, abundant common sense ಬೇಕು.
Otherwise ಆಫೀಸ್ objection raise ಮಾಡ್ತಾರೆ ಅನ್ನೋ ಒಂದೇ ಒಂದು ಉದ್ದೇಶದಿಂದ as per cause title of trial court.
ಅವಕಾಶ ಮಾಡಬೇಡಿ. You are an advocate, ಅಷ್ಟು ಹೇಳ್ದೆ you should understand. ಆಫೀಸ್ನವರು objection ಮಾಡ್ತಾರೆ ಅಂತ anything you can say? What is the first principle?
In order to show, I have produced the Aadhaar card also, my lord.
Next.
Kindly any date may be given, my lord.
Submission, my lord.
Yes.
Any date.
Serial number 30, my lord, I am held up in other courts. Serial number 30, a bail petition, my lord. 30.
30, huh?
Sorry, my lord, I am held up in court number 18.
ತಗೊಳ್ಳಿ, ಫೈಲ್ ಇದೆಯಾ? ಹೋಯ್ತಾ? ಏನದು? What is the matter?
Bail, my lord, 3 to bail, my lord. Other accused persons granted bail, my lord.
Appellant is accused number?
Accused number 5, my lord.
In all, how many accused?
There are total, my lord, total 12 accused person, my lord.
What is the stage of the case?
This is for framing of charge, my lord.
When he was arrested?
He was arrested on 23/9/24, my lord.
Date of offense?
Date of offense is, my lord, on 18/9/24, my lord.
18/9/24.
20.
Who are on bail?
Except accused number 1 and 2, my lord, other accused persons are all bail. I am producing the copy. What is attributed against accused number 1 and 2?
Where is the charge sheet?
Charge sheet at page, my lord.
Column number 17.
Please. Page 48.
Come to page 51. Yes, read it.
Please, ma'am.
ನ್ಯಾಮತಿ ತಾಲೂಕು. Read from
ನ್ಯಾಮತಿ
that.
ತಾಲೂಕು ಮರಿಗೊಂಡನಹಳ್ಳಿ ಗ್ರಾಮದ ಪಕ್ಕದಲ್ಲಿ ಹರಿಯುತ್ತಿರುವ ತುಂಗಾಭದ್ರಾ ನದಿಯಲ್ಲಿ ಶೇಖರಣೆಯಾಗುತ್ತಿದ್ದ ಮರಳನ್ನು ಕಾಲಂ 12ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಆರೋಪಿ ಮತ್ತು 2 ಆರೋಪಿತರು ಬಹಳ ದಿನಗಳಿಂದ ಅಕ್ರಮವಾಗಿ ಮರಳನ್ನು ಕಳ್ಳತನದಿಂದ ಸಾಗಿಸುತ್ತಿದ್ದು, ಈ ಅಕ್ರಮ ಮರಳು ಸಾಗಾಣಿಕೆಯ ವಿಚಾರವಾಗಿ ದಾವಣಗೆರೆ ಗಣಿ ಮತ್ತು ಭೂವಿಜ್ಞಾನ ಇಲಾಖೆಯ ಅಧಿಕಾರಿಯಾದ ಸಾಕ್ಷಿ 23 ರವರು ದಿನಾಂಕ 9/9/24 ಮತ್ತು 10/9/24 ಮತ್ತು ದಿನಾಂಕ 18/9/24 ಬೆಳಗ್ಗೆ 11 ಗಂಟೆಗೆ ಅಕ್ರಮವಾಗಿ ಮರಳು ತೆಗೆಯುತ್ತಿದ್ದ ಮರಿಗೊಂಡನಹಳ್ಳಿ ಗ್ರಾಮದ ಪಕ್ಕದಲ್ಲಿ ಹರಿಯುತ್ತಿರುವ ತುಂಗಭದ್ರಾ ನದಿಯ ಸ್ಥಳಕ್ಕೆ ಭೇಟಿ ನೀಡಿದರು. ಸಾಕ್ಷಿ 23 ರವರು ಮರಳು ತೆಗೆಯುವ ಸ್ಥಳಕ್ಕೆ ಬಂದು ಹೋದ ಮೇಲೆ ಈ ವಿಚಾರ ತಿಳಿದುಕೊಂಡು A1 ಮತ್ತು A2 ಆರೋಪಿತರು ತಮ್ಮ ಬೆಂಬಲಿಗರಾದ A3, A4, A5, A6, A7, A9, A10, A11, A12, A13 ಮತ್ತು ಕಾನೂನು ಸಂಘರ್ಷಕ್ಕೆ ಒಳಗಾದ ಬಾಲಕ ಕೌಶಿಕ್ ಎನ್ನುವವರನ್ನು ಕರೆದುಕೊಂಡು ಗಣಿ ಮತ್ತು ಭೂವಿಜ್ಞಾನ ಇಲಾಖೆ ಅಧಿಕಾರಿಗಳಿಗೆ ಮತ್ತು ಪೊಲೀಸ್ ಇಲಾಖೆಯವರಿಗೆ ಕೊಲೆಯಾದ ವ್ಯಕ್ತಿ ಶಿವರಾಜ್ ಮಾಹಿತಿ ನೀಡುತ್ತಿದ್ದಾನೆ, ಇವನನ್ನು ಬಿಟ್ಟರೆ ಬೇರೆ ಯಾರು ನಮ್ಮಗಳ ಬಗ್ಗೆ ಮಾಹಿತಿ ನೀಡಿರುವುದಿಲ್ಲ, ಇವನನ್ನು ಕೊಲೆ ಮಾಡಬೇಕು ಎಂದು A1 ಮತ್ತು A2 ನಿರ್ಧರಿಸಿಕೊಂಡು ಆರೋಪಿತರಾದ A3, A4, A5, A6, A7, A8, A9, A11, A12, A13 ಮತ್ತು ಕಾನೂನು ಸಂಘರ್ಷಕ್ಕೊಳಗಾದ ಬಾಲಕ ಕೌಶಿಕ್ ಇವರೆಲ್ಲರನ್ನೂ ಸೇರಿಸಿಕೊಂಡು ಆರೋಪಿತರೆಲ್ಲರೂ ತಮ್ಮ ಗ್ರಾಮದಿಂದ ಸೋನ್ಸೋ ಮಧ್ಯಾಹ್ನ 1 ಗಂಟೆಗೆ ಬಂದು A1 ಆರೋಪಿತನ ತಂದೆಯಾದ ಶೇಖರಪ್ಪ ಎನ್ನುವರಿಗೆ ಸೇರಿದ ಚಿ ಕಡದಕಟ್ಟೆ ಮರಿಗೊಂಡನಹಳ್ಳಿ ಗ್ರಾಮಗಳ ರಸ್ತೆಯಲ್ಲಿರುವ ಚಿ ಕಡದಕಟ್ಟೆ ಸರ್ವೆ ನಂಬರ್ 108ರ ಅಡಿಕೆ ಸಸಿಗಳಿರುವ ಜಮೀನಿನಲ್ಲಿ ಮೃತ ಶಿವರಾಜನನ್ನು ಕೊಲೆ ಮಾಡಲು ಸಂಚು ರೂಪಿಸಿಕೊಂಡು ಅಲ್ಲಿಂದ ಆರೋಪಿತರು ಅಕ್ರಮ ಗುಂಪು ಕಟ್ಟಿಕೊಂಡು ಅದೇ ಮೋಟಾರ್ ಬೈಕ್ಗಳಲ್ಲಿ ಅದೇ ದಿನಾಂಕ 18/9/24 ಮಧ್ಯಾಹ್ನ 1:30 ಗಂಟೆ ಸಮಯಕ್ಕೆ ಆರೋಪಿತರೆಲ್ಲರೂ ಮರಿಗೊಂಡನಹಳ್ಳಿ ಗ್ರಾಮದ ಏಕೆ ಕಾಲೋನಿಗೆ ನುಗ್ಗಿದ್ದವರ ಹೆಸರು ಶಿವರಾಜ ಬೈದಾಡುತ್ತಿರುವಾಗ ಮೃತ ಶಿವರಾಜನ ಹೆಂಡತಿ ಸಾಕ್ಷಿ 1 ರವರು ಮನೆಯಿಂದ ಹೊರಗೆ ಬರುತ್ತಿದ್ದಂತೆಯೇ ಆರೋಪಿತರಾದ A1 ಮತ್ತು A2 ರವರು ಮನೆಯ ಒಳಗೆ ಅತಿಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿ ಮನೆಯೊಳಗಿದ್ದ ಮೃತ ಶಿವರಾಜನನ್ನು ಎಳೆದು ಹೊರಗೆ ತಂದಾಗ ಆರೋಪಿತರೆಲ್ಲರೂ ಮೃತ ಶಿವ ಕೈಕಾಲುಗಳಿಂದ ಮೈಕೈಗೆ ಹೊಡೆಯುತ್ತಿರುವಾಗ ಬಿಡಿಸಿಕೊಳ್ಳಲು ಹೋದ ಸಾಕ್ಷಿ 1 ರವರಿಗೆ ಆರೋಪಿತರೆಲ್ಲರೂ ಸೋನ್ಸೋ ಅಂತ ಬೈದಾಡಿಕೊಂಡಿದ್ದು A1 ಆರೋಪಿಯು ಸಾಕ್ಷಿ 1 ರವರ ಮೈ ಮೇಲಿನ ಬಟ್ಟೆಗಳನ್ನು ಹಿಡಿದು ಎಳೆದಾಡಿ ಕೈಕಾಲುಗಳಿಂದ ಮೈಕೈಗೆ ಹೊಡೆದು ಒಳ ನೋವುಂಟು ಮಾಡಿ ಸಾರ್ವಜನಿಕ ಸ್ಥಳದಲ್ಲಿ ಅವಮಾನ ಮಾಡಿರುತ್ತಾನೆ. ಇಷ್ಟಕ್ಕೆ ಸುಮ್ಮನಿರದ ಆರೋಪಿತರು ಮೃತ ಶಿವರಾಜನನ್ನು ಅವರ ಮನೆಯಿಂದ ಹೊಡೆಯುತ್ತಾ ಎಳೆದುಕೊಂಡು ಅದೇ ಗ್ರಾಮದ ಶಿವಕುಮಾರ್ ಎನ್ನುವರ ಮನೆಯ ಪಕ್ಕದ ರಸ್ತೆಗೆ ಹೋಗಿ A1 ಆರೋಪಿ ಮೃತ ಶಿವರಾಜನನ್ನು ಬಿಗಿಯಾಗಿ ಹಿಡಿದುಕೊಂಡಾಗ A2 ಆರೋಪಿತನು ಶಿವರಾಜನಿಗೆ ಸಾಯಿಸಲೇಬೇಕೆಂಬ ಉದ್ದೇಶವಿಟ್ಟುಕೊಂಡು ತನ್ನ ಸೊಂಟದಲ್ಲಿದ್ದ ಚಾಕುವನ್ನು ತೆಗೆದು ಮೃತ ಶಿವರಾಜನ ಎದೆಯ ಎಡಭಾಗಕ್ಕೆ ಬಲವಾಗಿ ಚುಚ್ಚಿ ಚಾಕುವನ್ನು ಚುಚ್ಚಿ ಹೊರತೆಗೆದಿದ್ದು ಮತ್ತೊಬ್ಬ ಮತ್ತೊಮ್ಮೆ A2 ಆರೋಪಿತ ಚಾಕು ಹಾಕಲು ಹೋದಾಗ ಮೃತ ತನ್ನ ಎಡಕೈಯಿಂದ ಚಾಕು ಹಿಡಿದುಕೊಂಡಾಗ A1 ಆರೋಪಿತ ಮೃತನ ಎಡಗೈ ತೋಳಿನ ಮೇಲೆ ಬಾಯಿಂದ ಕಚ್ಚಿ
Venous mallet and the knife wound injury is on the vital part of the.
Maybe, but main assailants are accused number 1 and 2. And other accused are on bail 3, 4, 6 to 12. Similar allegations. Really the bail order. Bani. The appellant accused number 5 is before this court, seeking grant of bail. Heard so and so, they'll have to. The injured informant has given first information regarding the incident, upon which the FIR was came to be registered for the offence punishable under section so and so, so and so. After investigation, charge sheet came to be filed for the aforesaid offences against accused numbers 1 to 12. It is as per charge sheet, the main accused is the main assailants are accused number 1 and 2. And accused number 1 was the member of the Gram Panchayat. And accused number 2 is his son. And they are influential persons. They are the persons who are having motive to cause the death of the deceased and to assault CW1. Of course, this petitioner, as well as the co-accused, being the supporters of accused number 1, joined hands with them in commission of the offence. Next, when counsel for the petitioner produced the order dated 9/4/2025, passed in criminal appeal number 337 of 2025 with connected matters, to contend that accused number 3, 4, 6 to 12, against whom similar allegations are made, are already enlarged on bail by this court. This fact is not denied by the learned HCGP. When the co-accused, when accused number 3, 4, 6 to 12, against whom similar allegations are made, are already enlarged on bail by this court, by the coordinate bench of this court, I do not find any reason to deny the benefit of parity to the petitioner. Reasonable conditions may be imposed on the appellant while enlarging him on bail. Hence, the petitioner is entitled to the bail. Accordingly, I answer. Appeal is allowed. Granted bail. For the usual conditions, there are bail effective. Yes, allowed, subject to conditions.
First or matter. Number 24, Sirajuddin Ahmad.
For the appellant minutes.
Yeah, this is one. Amended cost rating. Counsel for the appellant submits that he has carried out the amendment in the cost rating. And also filed amended cost and amended appeal memo. Office to verify. Notice agida. This one. Is the mother of victim. Service of notice. Yes, what is the
My lords,
offense?
offense is POCSO Act, my lords. Appellant is accused number 2, my lords. She is a woman, my lords.
She was in custody during trial.
No, my lords, she was on bail, my lords, during trial, my lords.
The judgment there.
My lords, by order of CMIS 1117 of 21, 30/10/2021, she was on bail, my lords. At the time, on 30/10/2021, she was on bail, my lords. And thereafter, at the time of judgment, she was taken into custody, my lords.
The date of judgment?
Date of judgment is, my lords, 20.
Yes, what do you say? Suspension.
Please, Your Lordship, the role is regarding abatement, Your Lordship.
Accused number 1 is the main accused.
Please.
Appellant is the accused number 2.
Accused number 2, my lords. She is woman.
Counsel for appellant and learned additional SPP on IA1 of 2025. Adella format. It is noticed that the appellant is accused number 2, the lady being the mother of accused number 1. It is as per the case made out by the prosecution, she is the abater in commission of the offense. Initially, she was apprehended and enlarged on bail on 30/10/2021. During trial, she was on bail and was taken to custody only on the date of conviction. It is not the contention of the prosecution that the appellant had misused the liberty granted in her favor. Under such circumstances, I am of the opinion that the order of sentence passed against the appellant is to be suspended. The appellant is to be enlarged on bail subject to conditions which will take care of so and so. Accordingly, I answer the point idre affirmative in the format. IA1 of 2025 is allowed so and so, subject to conditions. IA is allowed.
Obliged.
Fine deposit ಮಾಡಬೇಕು ಅದೆಲ್ಲ ಹಾಕಿ. Is for admission.
Serial number 27, Method Maheshaya Rudraya.
Admission and call for LCR.
Huh?
Stages for admission also, my lords.
Admission again. Yes. 27.
27, Method Maheshaya Rudraya.
ಇಲ್ಲ ಅದು ಒಂದೇ. Counsel for the appellant sought for passover again better is absent no representation. This time notice ಮಾಡಿದೆ. Yes.
Sorry, 26. I'm sorry, Your Lordship. I was held up on my legs in the other court. 26, sir. Sorry. How the 26? 106, sir. Right. I was held up in some other, on my legs in some other court. sorry, Your Lordship. Great.
ಕೊಡ್ತೀನಿ ಇವಾಗ ಡೇಟ್ಸ್ ಎಲ್ಲ ಇನ್ನೊಂದ್ಸಲ ಕ್ರಾಸ್